So I'm here at the 35th District Court in Plymouth, Michigan, where my client and I just had the 8th motion hearing regarding production of an in-car videotape from the City of Plymouth Police Department. It's a state case, so it's the State Prosecutor's Office, Wayne County Prosecutor, APA, is handling the case, and we submitted a Freedom of Information Act request as well as a discovery request. And we received a number of videos from backup cars, and we received radio transmissions and the video from the police station, etc. But we did not get the video from the actual car that had stopped the client. And the client has maintained all along that he was illegally stopped by the police. He indicated that the police came up rushing on him really fast and stopped his vehicle for no lawful reason. And that, of course, is a very viable defense in a drunk driving case because the police need at least a level of reasonable suspicion before they can stop a motor vehicle. And if they don't, then all the evidence that's collected thereafter is considered fruit of the poisonous tree, and they can't rely upon their field sobriety test, preliminary breath test, signs of consumption or anything else like that to justify it after the fact. They need to be able to justify that traffic stop at the inception. Now, the City of Plymouth, they decided that they didn't have to turn over this video, and they wouldn't bother to tell us that they weren't turning over this video because lien information was contained, was recorded on the audio. Now, lien information stands for Law Enforcement Information Network. The lien has been set up for several years. It's a computerized network that allows the police to look up your driving record, to find out where you live, and all sorts of relevant, pertinent information pertaining to you and to me and every other motorist that's out there on the road. It's protected under a special statute, MCL 28.219, that makes this information super secret and private. No unauthorized personnel may access this computerized network. The computerized network, though, is the computerized network. It doesn't mean that if I know that another person has a criminal background because I looked it up on a computer network, that means all of a sudden that the entire damn video is exempt from disclosure. And I couldn't believe that they were exercising this defense, trying to claim that the entire video was exempt and that they didn't even have to tell us that they were hiding it because lien information was discussed by one of the officers while the field sobriety tests were being conducted. Ridiculous. It's an absurd argument. Thing is, though, is that it took us 8 court appearances in order to be able to persuade the judge over the prosecutor's objection to compel the disclosure of this video. And the entire while, the prosecutor was explaining that he could try to create a copy that would exempt that would erase this portion of the information. And just a few minutes ago, I argued in front of Judge Plakas here. I asked, well, if the matter proceeds to trial, is the prosecutor going to be willing to take the stand and testify under oath in his case that this is an accurate copy of the in-car video? The prosecutor had no good response for that. So I'm going to go back to my office now and watch this video. Hopefully it shows us some good stuff and we were able to proceed with this defense.